Senator Ludlam, for that, you can have the call.
If only it was always that easy.
It is in this committee.
Mr Chapman, I've got a couple of quick questions about the copyright infringement industry code. Can you just provide us, I understand it's with ACMA in the process of being registered. Do you want to just give us a bit of an update with what your work plan is for that?
Jennifer McNeil, I'm the General Manager of the Content, Consumer and Citizen Division at the ACMA. In general terms, Senator, a draft code was provided to the ACMA in early April, but the ACMA is not yet in a position to consider that code for registration.
Oh, okay.
At the time the code was presented, Communications Alliance, under whose auspices the code was developed, indicated that there were some outstanding matters still to be agreed with rights holders, and it's really only when a landing on those matters is reached that we'll be in a position to make a proper assessment of the code, how it works, its costs and benefits. So we're waiting on that, and there are a few other outstanding issues that we're working through with CA at the moment.
So it has been formally submitted to the ACMA for registration, or not?
It has been submitted.
And who submits it? Presumably your minister.
Communications Alliance submits the code.
And then they stop the clock?
When you talk about stopping the clock, I think your reference is probably to ministerial expectations. There is no formal clock under the Act on code registration processes.
Sorry, loose language. The Comms Alliance referred the code to the ACMA, but then requested that you put your assessment process on hold.
No, Comms Alliance submitted the code to us for registration.
Yeah.
We went back to Comms Alliance and indicated that we weren't in a position to consider the code until some further steps had been taken by them.
Can you just, thank you, thanks for clarifying. Can you just spell out for us what those further steps are?
The further steps are, firstly, the ISPs, the Internet Service Providers, who are bound by the terms of the code. As I understand it, they're still in discussions with rights holders around funding and indemnity arrangements.
Okay.
And as I indicated, it's really only once the authority has a sense of how those will work that it will be in a position to make a proper assessment of how the code will operate. I might add that those questions of cost and benefits also feed into the requirement that any code registration process be accompanied by a regulation impact statement, so we can't do a regulation impact statement without that information. There are, as I understand it, some residual concerns that the Privacy Commissioner has in relation to aspects of the code. It is only once we have, once the authority is satisfied that the Privacy Commissioner is happy that we can register a code under Part 6 of the Telecommunications Act. And thirdly, there are some drafting and enforceability matters that we are in discussions with CA about.
With Comms Alliance, okay. The feedback from the Privacy Commissioner and some of these other matters, if your process of registration hasn't really formally begun, are these just informal correspondence that you're referring to, or how are you aware, for example, of the Privacy Commissioner's concerns? The
Privacy Commissioner has written to us, and we have liaised with CA about those. So we're working through those things, and we're optimistic that it will reach a satisfactory landing.
All right then. What are your obligations for consultation? Do you actually run some kind of public process with those who, for, against, neutral or stakeholders, consumer representatives? Will there be a process where that occurs? No,
the public consultation process is run by the industry body that developed the code, in this case Communications Alliance.
Right.
In relation to this code, it did undertake a period of public consultation from the 20th of February through to the 23rd of March.
Yeah.
Separate from that, the authority itself has to be satisfied about the Privacy Commissioner's satisfaction with arrangements, and there are some formal certificates that have to be provided to us before we can register the code, but the public phase is really conducted by the industry body.
Okay. So I guess the time then for people to make their concerns known was at that time when they were undergoing that process, and a number of organisations, including ACAN, Privacy Commissioner, I guess, are two that I'm aware of, did did put some concerns on the record.
That's right, Senator. There were 372 submissions as a result of that public consultation process, and they've been published on the Communications Alliance website.
Yeah, but I'm aware of that. I'm just making absolutely clear that once it's with the ACMA, that's not the public input phase of the process has passed already by the time you get to sit down and nut it out.
It has. However, before the authority registers a code, it has to form the view that the code provides appropriate community safeguards. In reaching that view, it has regard to submissions raised in the consultation process or outside the consultation process.
And just to be clear, for those playing from outside the building, this is the sort of 3 strikes and we send around the lawyer's code.
I don't know that I would call it 3 strikes and send around the lawyer's code. I can indicate for those outside the building, as you put it, what the code is intended to achieve. So this is in the preamble to the code itself. The code provides for the creation of a scheme under which ISPs will accept notices from rights holders. The notices will identify internet protocol addresses that a rights holder alleges has been used to infringe copyright. In copyright work of the rights holder, the notices will request the relevant ISP notify the account holders of the alleged infringement.
Yeah.
ISPs will endeavour to match the IP addresses to the rights holders, identified by the rights holders to the account holders to which the IP addresses were assigned. So when there's a match, a notice is sent to the account holder, informing them of the alleged infringement and providing links to educational material, giving information about the sources of lawful online content.
Yeah.
Any account holder who receives 3 notices in a 12-month period will have the option to seek a review of any one of those notices.
Who does the review?
And where that's done by, I think, the CIP under the terms of the code. So this is a body which is, as I understand it, comprises representatives of the ISPs, consumers and rights holders. So it's a body of that kind.
Yeah.
Where an account holder receives 3 notices in a 12-month period and rights holder files an application for preliminary discovery in court, in those circumstances, ISPs will cooperate and support that court process. So that's sort of the big picture.
The court process involves the person who's alleged to have carried out the infringements or the ISP on their behalf?
As I understand it, the application for preliminary discovery would be made as against the ISP, and the preliminary discovery application would be an application to have details of the alleged infringer disclosed.
Are you concerned that the code could lead to the kind of mass copyright infringement lawsuits in Australia that have occurred in the US? Maybe the Dallas Buyers Club action, which we're reasonably aware of, is just really a taste of those sort of actions that we might see here in Australia? I'm not sure whether you're inviting me to give a personal view on such matters, but the short answer is no. So I should first say that the authority hasn't formed a view on the code. It hasn't formally considered the code for registration. That's fair enough.
But in the event that a code such as this was to be registered, it's a code which regulates the conduct of ISPs. It doesn't regulate the conduct of rights holders.
It regulates the conduct of users, actually. It's not really regulating the conduct of ISPs, is it? It's regulating the conduct of their user base.
It's regulating the conduct of ISPs in the sense that it creates obligations for ISPs, which would be enforceable as a registered code by the ACMA.
Okay. Yes.
Now, any engagement with, the court's processes, obviously, is a matter for the court.
Yeah. I think the chair wants to take us to a break at past. So my final... I'm almost done, but thanks, Chair. Is the process and its conclusion from here completely out of your hands? You just have to wait for Comms Alliance to come back and let you know that they've addressed those concerns? Or
I wouldn't describe it as being completely out of our hands. We are in touch with CA about the outstanding matters. All right.
Do you have any estimate of when that process might wrap and we might see the code be registered then?
I think it would be premature to speculate at the moment.
Okay. All right. I shall leave it there and I suspect to be continued. Thank you. Thanks.